Hello, everybody. Oh, wait a minute. Sorry. I had to raise my monitor up earlier because the kitties were helping me edit. And yeah, they're, they're not as helpful as they think they are. And so I always just raise my monitor up so that I can still see things because I can't see through them as much as they think that I can. Well, hello, you beautiful, wonderful, perfect little angel. Oh, the face, the face. Oh, she was such a good girl. I posted a short showing y'all what I'm dealing with the jackhammering. Yeah, it was not pleasant. And yeah, today was day 2 of that. And Ava, she just was a champ. She stayed right by Mama and made sure that Mama was protected. And she's just been so wonderful. Q's one of my favorite characters. I absolutely love him. I love him. Yes. Oh, hello, baby girl. Hello, Nana Laura. Hello, Lisette Panette. Hello, Eileen E. Carlin. Well, I'm here. I don't know if I'm ready, but I'm here. Oh, honey, it's okay. Yeah, we also had major storms today. So she is all kinds of one giant bundle of just not okay. Hello, Linda Applegate. Hey, I made it, didn't I? There's no such thing as wasted time. That's some good stuff. Hello, PH Jazz. We are doing wonderful, and we're so happy you're here. Hello, Spider-Man. Hello, Mark Ott. Oh, by the way, Linda Applegate, sweetie, I got your package in the mail. There's actually 2 packages coming, and I emailed you the tracking numbers. Hello, Sandy Hurd. That's okay, honey. We're gonna be here a while. I hope y'all cleared your calendar for now. Oh, honey. She's like on my elbow with her nose, just doing one of these. Like, come on. You have a free hand. Pat me, pat me, pat me. You're welcome, sweetie. I'm sorry it took me so long to get to the post office. I had a delightful time at the post office for the first time ever. They actually have a new worker there. I don't know if he transferred from another post office or if he's genuinely new, but he was absolutely a doll. And we got to talking because I knew the price of what the package was going to be roughly within like a few cents. He's like, "Oh, you've done this before." I'm like, "Oh yeah, I've got a YouTube channel and I mail out packages to my subscribers and stuff." And he was telling me about his 4-year-old nephew, and his 4-year-old nephew loves watching YouTubers. and that he kind of created his own little mock channel, and he wrote his own little spiel about Noah.com. So I told him if he wants, he can email me, and I'll design a YouTube logo with Noah.com on it for him, and get it sent out to him and stuff for his birthday or whatever he wants to do. Uncle stuff, you know? So that was absolutely adorable. I just I think it's awesome. And then Ava got invited to ride a train in Wisconsin Dells. Yep, they asked if I would go live and show their trains and take Ava on, because they do offer dogs on the rides. So yeah, Ava's gonna ride a train. Oh no. I've seen that happen. I don't want to say anything, but I've seen it. Oh, I've not heard it. Oh, I loved the ducks when I was a teenager. Heck, I lived 15 minutes from the Dells. I spent so much time there, and when Kendra was a toddler, we went to Knuckleheads like every day. Prior to her being in school, we lived at Mount Olympus and Knuckleheads. They were her two favorite places. Ava, the storm is over. Why don't you come up here? Come on. Come on. Why don't you come up here on the bed? Up on the bed. No, that's not the bed. Oh, sweetie. He's going to have a wonderful time. I understand being nervous, though. All right, the docket just got done. I did it in 4K instead of 8K. And no, I don't want to update yet. Clickety click buttons. She does. She doesn't realize how big she is. That sounds like a past tense statement. But I think that you should absolutely make a trip to the Dells and meet Ava. Peloton Pro! Hello, sweetie! And Freddie T. Cat. I'm so happy to see you. Looks like you're feeling better. Oh, don't make me. I won't do it. Sorry, I had to mute myself to cough. 14 hours. We absolutely will. We will be sending you all the good vibes, all the prayers, for you as much as for him. All right, guys. So tonight we're going to go see an old friend of ours, Magistrate Burton. We haven't seen him forever. And we get to see Reagan and his sassy mouth. And we're also going to see Judge Hesselink. So, yep. Fun stuff. And I did put, there is a case at the very, 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 very end. I put it at the very end for a reason. It might be hard for some people to watch. So I'll get into a little bit more detail when we get that far, and whoever's still awake at that time can determine whether they want to stay or not.
All right, Ms. Burnett, we're going to start off with you. You have two cases. But before we start out, Ms. Burnett, you have some traffic matters in which you failed to appear in court for. As a result of your failure to appear, warrants for your arrest were issued. The court's going to set aside these arrest warrants, give you a personal bond in which these misdemeanor matters that carries a maximum penalty of up to 90 days in jail and or a $500 fine. You have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney. Can afford an attorney, one will appoint on your behalf. The ticket is P1323876. Driving an unregistered motor vehicle, no insurance misdemeanor. Pre-trial, July 11th, 9 a.m. in front of Judge Tanisha Yancey. Now to your two other main cases. Case number 200-598-9301, Pure State, Michigan versus Portia Burnett, and case number 240-450-8701, Pure State, Michigan versus Portia Barnett. Appearances, please.
Good morning, Lisa Coyle appearing on behalf of the people.
Good morning, Ms. Coyle. Good morning, Your Honor. Christina Harris, P52857 on behalf of Portia Burnett, who stands and waits a formal reading of a complaint. And Ms. Burnett has been advised of and understands her statutory and constitutional rights.
All right, the court will enter a guilty plea on behalf of Ms. Burnett. I have a capious bond, $1,000, 10% set yesterday.
Yes.
Judge Bryant.
2325.
I got six. I'm reading it 625-25.
2425.
Okay. And hold on. Are both cases capiouses?
Yes.
I didn't hear that last word. Of both cases.
Yeah. Okay. Either June 24, 25. One for review, one for pretrial. $1,000, 10% capious bond for both, set by Judge Bryant. Ms. Harris, why should I not continue both of these capious bonds?
Ms. Burnett did not have the transportation, but she did get on the bus. She got on the wrong bus and she was late to court. And so, and then she was picked up by the police. So she's saying that wasn't necessarily her fault because she was trying to get to the court. She got on the wrong bus.
Did she get to court?
So she got on the wrong bus and she was late to court. So
how late?
Can I say?
Go ahead, ma'am.
I kept calling and I was speaking to someone that was in Mrs. Bryant's courtroom. There was a guy there, but I kept calling to keep in touch with him. But I was on the wrong bus, and by the time I got down there, I ended up on 7 Mile and Myers, somewhere down there. But then that's when I got picked up. But I had spoke to her her assistant, and I tried my best to keep in touch with them because the person that was going to bring me had no license and no driver's license, and I didn't want to risk getting in the car, and the car didn't have no tags or anything. So I tried to get on the bus myself, and this is how I had got picked up by the tether people.
What bus did you catch, man?
To get down here, I did.
Hold on, Ms. Burnett. What bus did you catch?
I was on the 6 Mile bus, and then I ended up, somebody told me I had to make it to the 7 Mile bus. But when I got to the 7 Mile bus, I don't know, I was supposed to make it to Woodward somewhere, but I never made it to Woodward because I went from 6 Mile and then I had made it to the 7 Mile. I stayed on 7 Mile in Southfield, but I was located on Birdwood.
Okay, hold up, slow down. What bus did you initially catch?
6 Mile.
And at what?
Burwood.
So you could catch the 6 Mile bus to Woodward, get a transfer, come downtown?
I didn't know I had, that's where I had, because I don't have a telephone. So I just try.
So how'd you call? Well, you didn't have a telephone. How'd you call the clerk? How'd you call Judge Brian's courtroom?
When I called before I left the house. I have a phone at the house. And then when I made it to Burwood, I used someone's over there. And then that's when they had told me I got to get to 7 Mile. So they just kind of guided me from there. But I used the phone twice and I called up there. So I called before I left home and I called when I made it to Burwood and 6 Mile.
Reagan, you have something you wanted to add?
Yeah, in here.
What's this mean? You good? It's all good, guys?
Sir, if I might go ahead.
Hold on. JCF Hearings. What is your name, sir? Sir, just logged in. What is your name?
Nowacki.
Oh, no, not you, sir.
What?
Nowacki.
Okay.
I apologize, Judge. Did you ask me a question?
Corrections, Your Honor.
No, I thought either you or Ms. Harris was about to log make a statement for Ms. Burnett.
I was.
Either one of you go for it.
Okay, that she stated she has some confusion. So it seems that she was making an effort to get to court. Everybody is not savvy about which buses to take and in which direction to go if you don't know how to get downtown. So Your Honor, we're asking you to reinstate the personal bonds for Ms. Burnett. And she gives her, Ms. Burnett, you do give your assurance that you will come to court for your next court. Thank you. Your Honor.
I've been keeping.
Judge Williams, hold on. We got a lot of moving parts here. Judge Williams, once I finish with this case, we're gonna do Shamika Norfolk, the felony Cape bonds. So just give me about a couple minutes.
Hey, take your time.
Okay. All right, Mrs. Coyle, your response.
Yes, I'd like to be heard on both of these cases because on the first case, which I talk about the unlawful custody or the lawful custody, the ending in 87, Your Honor, there were 3 failures to appear. This is from February of 25. So each time she was given a personal bond, including tethers, she violated, and you gave her, in fact, back on May 1st, 1,000 personal with the tether, and she failed to appear. So she's had 3 failures to appear on that matter. On the case that was back from 2020, she had 6 failures to appear on that matter, which every time she was given a break in that a felony was reduced to a misdemeanor. Then she fails to appear, and on that matter, I think you're the last one too, that gave her another $1,000 personal bond with the tether, and she still fails to appear, Your Honor. So between the 2 cases, she has 9 failures to appear. So there's a point when this is just becoming ridiculous. So I'm asking for on those bonds to remain at 1,010%. Tethers don't seem to work because she's been given a tether. She's been several times and she fails to still report. So based on that, Your Honor, I'm asking, this is 9 failures to appear within 2 cases within a short period of time. These cases, the one in the 24 case just started in February and she's had 3 on that alone. So I think there's a point when it just becomes redundant and that she decides when she decides to come to court. She only comes to court, it appears, when the police pick her up or she gets picked up on something else. So nothing further to say.
Excuse me, sir. I've been dealing.
Hold on, Ms. Burnett.
Sorry.
You've spoken with your attorney. They're going to advise you not to state anything, but it is your right to question. But they're going to advise you. They're very, very good attorneys. Go ahead.
Okay, Ms. Burnett, you have the right to remain silent. Anything you say can be held against you. You are on a recorded Zoom. The prosecutor is here, and I don't want you to say something that can be held against you.
Okay.
Hey, now, do you still want to speak?
No, ma'am.
Okay, thank you, Ms. Burnett. I'm just trying to protect you.
Yes, ma'am.
Okay. All right, Ms. Burnett, I can applaud your good faith effort to catch the bus. However, that's just for one time for this past, either yesterday or 2 days ago. I grew up catching the bus. One of the first things I learned how to do as a teenager was to catch the bus downtown. It can be complicated, but it is fairly straightforward, particularly if you come from Northwest Detroit. You catch the bus to Woodward, get a transfer. The Woodward buses are one of the major thoroughfare. They run every 10 to 15 minutes, and you could have been downtown easily within an hour. Okay? So being confused or whatever, to a certain extent, I can buy that, but to a certain extent, I don't. And I think it's just another excuse given the 9 times between these 2 cases that you have failed to appear. So I am going to continue the capious bond set by Judge Bryant in both of these matters. And you'll have a bond determination hearing on Monday, June 30th for both of these. Pretrial for both of these cases would be July 8th for review and or pretrial in front of Judge Bryant. Ms. Burnett, do you have any questions regarding your court dates and or bond conditions?
That 1,000 cash?
1,010%.
1,010%. Thank you on both cases.
Both cases.
Thank you.
So,
Okay?
yes.
All right. All right. Have a good day, ma'am.
State of Michigan versus Stanley Huffman, file 24-42897-SD. All right, I do see Mr. Huffman.
Good morning, Your Honor.
Good morning. Mr. Huffman, there is a probation violation alleged against you. It reads as a second technical violation that you have not, that you have failed to test on May the 20th and May the 23rd. That you are not consistently calling the testing line Monday through Friday as required. And the recommendation is that you serve 2 days in jail. You understand the allegation made against you?
Yes, Your Honor.
You understand the recommendation for 2 days in jail?
Yes, Your Honor.
All right, as to this probation violation, you have the right to enter a plea of admission or denial. Admitting is saying that you did it, denying is saying that you didn't. If you wanted to have a hearing on that, you'd have the right to be represented by an attorney. You have the right to have a hearing in front of me as a judge. You do not have the right to have a jury trial. At that hearing, you'd have the right to see, hear, and question all the witnesses against you. You'd have the right to present witnesses on your own defense and get an order from the court called a subpoena to require those witnesses to appear and testify. You could testify or you could remain silent. And if you chose to remain silent, that silence could not be used against you. You'd also have the right to be presumed innocent until proven guilty by a preponderance of the evidence, and that burden would remain with the probation department. And finally, you'd also have the right to appeal. Do you understand all of those rights?
Yes, Your Honor.
Do you have any questions about any of those rights?
No.
Do you wish to have an attorney represent you today, or do you want to represent yourself?
I'd rather represent myself.
Has anybody promised you anything or threatened you in any way to get you to do that?
No, Your Honor.
All right, how then do you want to proceed today? Do you want to have a hearing or do you want to admit the probation violation?
Really, honestly, this whole charge, I wasn't even drinking and driving. They waited an hour. Just hear me out for a minute, Your Honor. Just hear me out. I know this isn't an excuse at all, but the whole charge, I wasn't even drinking and driving. I have a whole documented of the time that the cop was waiting there while he was waiting to arrest me. He waited an hour just to come up to my vehicle. I wasn't drinking and driving. So this charge, I should have fought this whole thing in the first place. I wasn't drinking and driving at the time. I drank when I was sitting in my truck. And then they pulled up to me an hour later when I was already drunk and then assumed I was drinking and driving. Now, for me, not calling the calling line, I am calling the calling line. Sometimes I miss it because I'm living in my truck at the moment, working 60 plus hours a week. I don't make that much, but I'm trying to go down the right path right now. And I had to leave my house and home and my family to go down this path. Did I want to make that choice? No, because my daughter's going, now she's alone without me, and I am struggling. And the court system is supposed to be here to help us, but you guys keep giving us violations when we're in a hard time. And I understand I need to follow the guidelines, but this whole charge, I should have fought it in the first place. No, yes, I was in the wrong in the first place for even drinking in my vehicle. Yes, but I wasn't drinking and driving. I wasn't doing what they said I was doing. And I am trying so hard to stay on the right path. Yes, you're only giving me 2 days, but 2 days is a lot of money I'm going to miss. And work camp, it is so hard with my job to take off time to just go and do work camp and pay them to do the work. It is hard to do that. It's literally risking my job because my boss is he's very picky. I work at Lucky's Steakhouse. If I take time off a couple hours, that's going to risk the whole day throughout the day because the prep didn't get done. And money in my pocket paying you guys, paying, excuse me, paying work camp, and also paying for all my other bills that are still at the house and I'm still paying for. It's not like I don't want to do this stuff. I do want to do it. But probation is making it more of a hinder on me and making more bills for me than it is helping me. I'm still doing counseling. I'm doing everything else I'm supposed to be doing. I haven't caught another charge. I've been doing good. It's not exactly the easiest thing in the world for me. This is the furthest I've probably made it on probation in a long time.
Mr. Huffman, I was not here as the judge when you pled back in October of 24 in front of Judge Cooper, but you decided, nobody else, you decided to enter a plea. I can't unchange that. I can't go back and say well, you've had a change of heart. You don't agree with that now. That decision has been made. You decided to go down this path, putting yourself under the authority of the court and accepting what the court was going to do by way of a sentence. All I can do is say, have you met your obligations under that set of circumstances? I can't, I hear you. I understand that it's difficult for you, but life is full of difficult circumstances. All right. This is the path that you chose. Nobody forced you to do this. You decided back in October that this was the lesser of two evils, I'm going to guess. That it was better for you to take this path than it would have been to try to fight it and go to court, go for trial. All right. So you've made that decision, and whether you like it now or not, that's where you're at. Okay.
Nobody else's choice but mine.
Exactly. So I've always found that the people that do the best are the ones that say, all right, I made that decision. That decision's done. What's the best thing that I can do today? And it's not to fuss about, I should have made a different decision. Okay. I get it that it's okay to grouse a little bit every once in a while. And that's why I didn't say anything when you started talking. I said he needs to vent. And so we let you do that. Okay.
Thank you.
So, but now,
thank you.
Now as an adult, and I'm trying to treat you as an adult. Now as an adult, you've got to work with this difficult decision. You've already made that decision. The consequences are that you're under the court's authority, and the court required you to do certain things. I get it. And quite frankly, the court is supposed to be hard. It's supposed to make you want to change how you do your behavior, right? It's supposed to make you think. And it appears to me that it is. It's working that way. But you're still not out of that old way of thinking, which is, it's hard and I don't want to do it. Yeah, it's hard. It's supposed to be hard so that you learn never to go here again. You understand what I'm saying to you?
No, that was really wise, actually. Thank you, Your Honor. Thank you.
Well, I appreciate that too. So it's a growing process for you, and I understand that.
It's
So that's why I'm
it's
not mad at you. All right, I'm not mad. I'm not going to do anything bad to you, other than to say you got to do what your obligations are. Just like your
it's
boss
taken
in
a
Lucky
lot to
says,
change
hey,
my mindset.
it
Taken a
does.
lot.
It's a process, and I hear you getting better. I see you getting better. You just need to speed it up a little bit. All right.
Yeah.
So
Yes,
we're
Your
all
Honor.
right. So here's what I'm going to do. I'm going to adjourn today's hearing for 30 days. If you miss anything that you're supposed to do, I'm going to probably increase the amount of jail time. Or
Yes, Your Honor.
if you don't miss, then I'm going to dismiss the matter. You
Can we,
understand what I'm saying to you?
Yes,
So
Your Honor. Can we do something about
I'm going
work
to give
camp?
you a
I'm sorry.
chance. All right. I'm going
I
to give you
can't.
a chance to prove to me that you've grown up and that you will take responsibility. So Ms. Hill, we're going to simply adjourn today's hearing for 30 days, put it back on the docket in 30 days. Mr. Huffman, as long as you're doing everything that you're supposed to be doing, we're good. And I'll chalk it up to you've grown up. Okay?
Thank you. Thank you, Your
All
Honor.
right. Go back to work, earn some money, get these things done.
Yes, sir. Thank you. God bless. Thank you.
You're welcome.
Okay, are we ready on the hospital arraignment?
Yes, Your Honor.
Okay. Okay, Mr. Barnes, unmute, state your name for the record.
Ramon Barnes, Your Honor.
All right, this is case number 250-583-5201. Peace and Michigan versus Ramon Barnes. Appearances, please.
Good morning, Lisa Coyle, appearing on behalf of the people.
Good morning, Your Honor. Jessica Shai, P number 81798, on behalf of Mr. Barnes, who waits for more reading, understands his constitutional rights, stands mute.
All right, the court will enter not guilty plea on behalf of Mr. Barnes. Bond recommendation?
Your Honor, in this matter, the people are recommending a $75,000 cash surety bond, and based on the allegations here, I don't see a criminal history for Mr. Barnes, but I do see is what predatory nature of the contact that he had with Mr. Collins. Mr. Collins is now the current boyfriend of Mr. Barnes's ex-girlfriend, and that this is all captured on green light video at the gas station. The officer describes it in the IR as the defendant gets out of the car with a gun in his hand, racks the gun. He punches the complainant, gets into a fighting stance. The complainant, who is a valid CPL holder, shoots the defendant in the leg. The defendant then fires his gun at the complainant. There were casings found at the scene, 440s and 2 9mm. People believe, based on the confrontational nature, even though he doesn't have a criminal history, that he is a danger because he hunted him down based on no reason. And this is all, the evidence is great. Not only do we have the witness of Mr. Collins and the girlfriend, but we also have it captured on green light video. Thank you.
Response?
Yes, Your Honor. My client is 34 years old, and as we just heard, in his 34 years, he has no criminal history whatsoever. You just don't wake up at 34 years old and decide to be an assaultive person or go shoot somebody, which he didn't shoot anybody. He's in the hospital because he had to get surgery for gunshot wounds from the complaining witness, because the complaining witness, Robert Kahns, is who shot him.
A little correction there. He shot at the complaining witness. He just happened to miss, and the complaining witness didn't.
And, you know, in the report, there's conflicting things. In the report, it indicates that on green light video that my client moves the gun from one hand and doesn't shoot him, doesn't threaten him, allegedly punches him. My client indicates he didn't touch anybody. Yet when they talk to the complaining witness doesn't talk about that. He doesn't say I got punched. He doesn't say I got punched or nothing. Probably because if you get punched, you don't shoot somebody back. If you don't shoot somebody who is punching you. You don't bring a gun to a punching or fist fight, Your Honor. So there's conflicting things, paragraphs right after another, because he doesn't say he got punched. He says he pulls out the gun, here's Iraq, so he shoots him, and then he leaves. And this woman that's in the car with him, that is the witness, who is the ex-girlfriend, has hired multiple people to threaten not only my client, but his mother and his wife. And there is documentation of this. My client has made several police reports against this because this woman has been hiring people to threaten my client, to say these words specifically, "We going to get you," texting that from Google numbers and private numbers, and calling and saying that when he picks up. So the predatorial person here is probably the woman in the car who makes this guy shoot her ex-boyfriend. Who's in the hospital? My client. Who's injured? My client. Who fired a shot? The complaining witness, Your Honor. So my client has no history whatsoever, not on probation or parole, nothing pending, just lost his second job because of this. That's how he supports his 8-year-old daughter. He lives with his wife and daughter, a lifelong resident, no capious history. So I think here the person who should be in front of you is the actual person who shot at my client, and not my client who has been getting threats and has people getting hired against him to threaten him and his family. That's very scary, Your Honor. And he's made police reports. That's what he's done. He's gone to the police. He did the right thing. He documented all this, and he's told them multiple times that him and his family are being threatened. So there are two sides to every story. We weren't there. If my client had some criminal history, maybe this would be a different way. If he hadn't reported what there was happening, it's different. But I'm asking for a personal bond. And if the court is not inclined to give him a personal bond without a tether, I don't even want to ask for that. He got shot in the leg. He needs physical therapy to start walking again. He's not able to walk there. That was confirmed by him there, the officer there, in the hospital. So I'm respectfully asking the court to consider a high personal and no contact, and he's going to be getting a PPO against the witness here, because he's gone to the police and the threats have become real, and he actually got shot at, Your Honor.
You said he lost his job?
He has lost his second job now because he's been in the hospital for 2 days getting surgery after being shot.
So he has no job now, is that correct?
Correct.
No.
Oh, I'm sorry. You lost your second job, but you have 2 jobs?
Yes, I still have one job.
Okay, so the job that you still have, what are your work days and work hours?
It's caregiving, so it was like 40 hours a month for different clients.
Okay. All right. Court haven't heard the argument as to bond. The facts of this case are very, very peculiar to this court. The investigator's report alleges that Mr. Barnes cut off Mr. Collins, got out of his vehicle, and then with a gun, does not shoot the gun, but an argument could be made that he carried it and approached it in a threatening manner, and then physically assaults Mr. Collins. Mr. Collins thereby shoots Mr. Barnes because I believe one can feel reasonably threatened if you cut off your girlfriend's ex-boyfriend approaches the vehicle in a threatening manner with a weapon and an aggressive, and then allegedly has some assaultive behavior toward the complaining witness. So an argument can be made, I'm pretty sure it is, that Mr. Collins acted in self-defense. So notwithstanding the fact that Mr. Barnes does not have a criminal history, on a certain level, he was the aggressor in this situation by allegedly cut him off and approaching the vehicle with a weapon, which can be threatening, can be perceived as threatening by any means or measure, by any reasonable man or woman would perceive that as a threatening situation. Does not appear that Mr. Barnes is a CPL holder, but the complaining witness was. And so the court, considering all the totality of the circumstances, I believe emotions are running high because I'm just guessing that he saw his ex-girlfriend with her current boyfriend and somehow he got triggered. notwithstanding what Ms. Shive represents in terms of the threats or whatever, this is a toxic situation. And I'm afraid of it escalating even further. And this occurred just 2 days ago. Yeah, he may not have a record, but he does carry a gun, at least in this incident, when he's not illegally allowed to. I'm not sure whether they were stalking or he just happened to see the complaining witness, but nonetheless, there's a lot of intent that can be inferred here, given the cut him off, approaching the complaining witness with a handgun. I agree with Mrs. Coyle. I do find that he's a danger to the complaining witness, notwithstanding the fact that he got shot. And so I'm going to give him a $75,000 cash surety bond. No contact with Robert Collins. He was able to post bond GPS tether, 9 p.m. to 6 a.m. curfew. Although I wasn't there, an argument could be made that Mr. Barnes was stalking the person, but that'll all come out later on in later court dates. But an argument could be made to that effect. I assume this is an unaffordable bond.
It is, and I just want the record to reflect that the people out there threatening and shooting people are out free while my client is in a hospital with a $75,000 cash bond. People who actually have police reports against them and people who actually fired a weapon. Just so the record can reflect who's out there on the streets still being a danger and who's locked up in a hospital on a $75,000 cash.
Well, that may very well be true, Ms. Shive, but the person that allegedly shot your client is a CPL holder. Your client isn't.
But if my client was a CPL holder, it doesn't change because we have CPL holders, and if they allegedly shoot somebody, we've made those arguments. And the fact is, it doesn't matter. Just because you're a CPL holder doesn't mean you can shoot people and be out and free.
Okay, that may very well be true, and I don't want to go back and forth with this with you, but I'm saying the complaining witness is a CPL holder, and the facts and investigators report that your client was the aggressor. So those are the reasons why. If he was in fear of being threatened, one would think he would go the opposite direction and go far away from the complaining witness. But it doesn't appear to be that fearful of this situation. So those are the reasons I find that he's a danger to the complaining witness. Bond redetermination will be Monday, June 30th, 9 a.m. from the Chief Judge Mechanical. Probable cause July 7th, preliminary examination July 14th, both in front of Judge Giles. While this case is pending, sir, you're not to possess any handguns, firearms, or other dangerous weapons. No contact with Robert Collins.
Well, I mean, it's such a good thing that you just made it a condition of his bond. I mean, because he complied with firearm laws so well prior to it being on paper. I mean, you know, he's just a law-abiding, gun-owning without a concealed carry weapons license, you know, kind of person.
Mr. Barnes, do you have any questions regarding the bond conditions and no court dates?
There's no personal. It's not 10%.
No personal bond for you, sir, today. Upon your
10%.
bond determination. No 10% today. Your attorneys will re-argue for your bond, 10% and or personal bond on Monday, June 30th, okay?
Am I allowed to say anything?
Do you have any questions regarding your bond and or court dates, Mr. Barnes?
No.
Is that a no?
Yes, that's a no.
Okay, so you don't have anything to say or no questions. So have a good day, sir.
I was going to ask if I could say something, Your Honor.
Ms. Shive.
Well, sir, you have a right to speak. Just be mindful, prosecutor's on, and it's all part of the record.
Okay.
You still want to speak?
No, sir.
Okay, have a good day. Who's next? Mr. Watson?
Judge, we've been waiting for a breakout room, I think.
For who?
Mr. Nowicki.
Oh, when were you going to tell me?
I thought I told you.
I had 3 breakout rooms going on simultaneously, sir.
That don't mean I didn't tell you.
Well, I didn't. More importantly, I didn't hear you. How about that?
Yes, sir. Yes, sir. I got
Okay.
you. Whenever you are ready, Your Honor. Whenever you are ready.
Okay. Mr. Nowicki, I'm gonna put you in a breakout room with you, Mr. Reagan.
Thank you, Your Honor.
Okay.
Ooh, Reagan still has that sass. And by the way, I was there. He never asked.
Give me one moment. Problems. Are we ready on Mr. Berry?
Yes, Your Honor.
Okay. Mr. Berry, state your name for the record.
William Berry.
This is case number 250-583-5601. People of Michigan versus William Berry the fourth. Cases, please.
Lisa Coyle appearing on behalf of the people.
Christina Harris on behalf of William Berry IV. He stands mute, waives the formal reading of the complaint, and Mr. Berry has been advised of and understands the statutory and constitutional rights.
All right, the court will enter not guilty plea on behalf of Mr. Berry. Bond recommendation from the people.
People are recommending, I understand it's non-assaultive, Your Honor, but people are recommending a 10,000 cash surety tether house arrest if he is able to make that bond. This is, officers tracked this stolen car he was getting in and out of. He possessed a key fob to it. There was a stolen gun also found on the front passenger seat. He has many recent convictions, a 2024 prisoner possessing contraband, which he got 2 years probation. So I assume he's still on probationary status. He also had a 2024 RCSP over 20,000 under HIDA status. He also had a 2023, which he had 3 years probation, but this is under HIDA status. B&E building 2 counts, UTA 2 counts, RCSP motor vehicle, MDP over 1,000, and a fleeing elude 4th. As I said, they're all under HIDA status. Based on his record recent and the nature of this case, people believe not only that he's a danger, but he is a possible flight risk. So for that reason, I'm requesting that tether as well. Thank you.
Thank
In
you.
response, Your Honor, Mr. Berry has no history of not coming to court or missing court hearing dates. He is employed at a landscaping company. He states he has a child on the way and he is really trying to get back to work so that he can prepare financially for the child that is on the way. He works in landscaping Monday through Saturday, 9 a.m. to 5 p.m. He's a GED holder and he will return for all future court hearing dates. We're asking for a personal bond in this matter. Thank you, Your Honor.
He works, what, 6-7 days a week?
6 days a week, Monday through Saturday, 9 a to 5 p. For landscaping companies, this is a busy season.
Nine a.m. to 5 p.m.?
Yes, Your Honor. Monday through Saturday.
Okay, this incident allegedly occurred on Monday, June 23rd at 4 p.m.
I was just going to say.
Those are the work hours he has indicated.
I don't doubt that.
Your Honor, we really don't know, in all honesty, what his, whether he has a KPS record, because most of his convictions were under HIDA status, so none of us can look at them. So that's why the tether is important in this matter.
Okay. I was pointing that out. He has a GED. Does he work for a, what type of landscaping company does he work for, or does he work for himself?
We can inquire. Mr. Barry?
I work for a landscaping company called STK Landscaping and Contracting. And actually, since I've been home, I actually started my first business, which is called All in the Family Landscaping. And you can
All in
look
the
up
family,
STK
hold on, all in the family what?
Landscaping. So I'm starting my own business after, like, pretty much since I've been working. I've been learning the ins and outs of my job, and since I got my GED, I've been very educated in business aspects, and that if I actually put my mind to it, I will actually be able to change my history, because obviously I have a terrible history, but I'm actually working towards making it better. And if I was able to make bond, I would be able to bring proof that I actually started this business, because it is filed with the Michigan. It's filed
When did you
I would just like to clarify, my guy, you can't change your history. What you did, it's done. You did that. You can change your future. And that I would completely commend you for. But, changing history, nah. Only the media does that.
When did you establish and file this business?
In February of 2025.
Your Honor, I just looked at his driving record. He has a suspended driver's license too.
Okay. All right, court haven't heard enough argument as to bond. I'm not going to give you a cash bond, but I'm going to give you a $50,000 personal bond, GPS tether house arrest. You've got a lot going on here, and I can't make heads or tails as to what is what. But I think you need to sit down for a minute. I don't necessarily give any credibility to your work hours or to how you're working or whatever. If it is true what you tell me that you set up a business or whatever, I applaud that. But short of giving you a cash bond, which I think is warranted to a limited extent, you got a lot of contacts with the criminal justice system. I think you just need to sit down and have some moment in the house and prepare for your child and have some time for reflection. Probable cause July 7th, no examination July 14th. Also, while this case is pending, you're not to possess any handguns, firearms, other dangerous weapons. In addition, no driving. Mr. Berry, do you have any questions regarding your bond and or court dates?
No, Your Honor.
All right, thank you. All right, thank you, Dearborn.
Thank you.
Your Honor, the PCC
All right.
date?
July 7th, July 14th. What's your name, sir?
Anthony Blaylock.
All right, this is case number 250-454-7101. Precinct Michigan versus Anthony Blaylock. Appearances, please.
Lisa Coyle appearing on behalf of the people.
Christina Harris on behalf of Anthony Blaylock, who stands mute, waits a formal reading of the complaint. And Mr. Blaylock has been advised of his statutory and constitutional rights.
All right, the court will enter not guilty plea on behalf of Mr. Blaylock. Ms. Harris, Mr. Blaylock has a $500 cash capious bond set by Judge Garrett 2 days ago. Where was he, and why should I not continue that capious bond set by Judge Garrett?
Where Mr. Blaylock works 9 a.m. to 2 p.m. He was at work. Mr. Blaylock, do you give your assurance of a personal bond is given that you will come back to court and you will not miss court?
I do. Solemnly swear.
You were at work 2 days ago?
Yes.
You forgot?
Yeah, I thought it was the 28th instead of the 24th. I was surprised at that. It just was a miscalculation on my end because I didn't have my cell phone.
So how'd you get picked up?
I'm sorry, just say it again.
How did you get picked up?
Young lady in question came to give me my property at my house, and to be honest, she said, "If you don't sleep with me, I'm going to call police on you." And there.
Oh my goodness! I'm going to continue.
He has borderline.
No, I don't want to
Okay.
hear anymore. I don't want to hear anymore. I'm going to continue the capious bond set by Judge Garrett. I've heard of a lot of excuses in my time, and this is in the top 20. I was going to give you the benefit of the doubt if you had turned yourself in, but apparently that was not the case. So the court's going to continue that $500 cash capious bond set by Judge Garrett. Is that I'm gonna, just to be safe, you'll have a bond redetermination hearing Monday, June 30th, 9 a.m. in front of Chief Judge McConaughey.
This has got to be the only guy in history that chose jail over sleeping with that girl. I mean, that's pretty bad. I mean, that says a lot about her more than about him, I think.
Oh, so I'm sorry. So you say
Go ahead, sir.
I'm sorry, it's a signal. I couldn't hear you. So you are continuing the bond that I'm already on?
Yes, sir. $500 cash. That's what you need to get out. Bond redetermination will be Monday, June 30th, 9 a.m. in front of Chief Judge McConaughey. Pre-trial in person, July 7th in front of Judge Garrett. As I indicated, I thought you had, I was going to give you a personal bond if you had turned yourself in, because I can understand how people forget stuff at their work or whatever, but that does not appear to be the case. And so that's why I'm continuing the capious bond in this matter.
You would allow me.
All right, I'm sorry?
You would allow me to speak. That is the case. Like, she came to bring me my property, and I'm like,
Mr. Blaylock,
Blaylock.
Okay.
please don't say anything, please.
I appreciate you guys. Thank you.
Thank you.
All right, no contact with Ms. Edgar. You're not to possess any handguns, firearms, or other dangerous weapons. All right, Mr. Blaylock, do you have any questions regarding your bond and or court dates?
So you say I have to pay $500 bond?
Yes, sir.
Thank you.
All right. Zamira Winder?
Yes, sir.
All right, it's case number 250-583-4501, Peace of Michigan versus Zamira Winder. Appearances, please.
Lisa Coyle appearing on behalf of the people.
Christina Harris on behalf of Zamira Winder, who stands mute, waives a formal reading of the complaint, and Ms. Winder has been explained and understands her statutory and constitutional rights.
All right, the court will enter not guilty plea on behalf of Ms. Winder. Bond recommendation from the people.
Your Honor, the people are, based on the severity of this, asking for a $10,000 cash surety with a tether. I do understand Ms. Winder is about 22 years old. The complainant, Mr. Pitts, is about 23 years old. They had a relationship of dating 2 years, but I don't see a criminal history for Ms. Winder. But based on the assault allegations that she was poking him in the face, videotaping it on the phone, she tried to stop him from leaving. Now, the allegations are she slapped him in the face over 20 times with an open hand, bit him in the chest, slammed the car door on his head and body about 7 times, and damaged his car. So for those reasons, Your Honor, based on the obviously a domestic violence situation that's out of control, and that he did suffer bite marks to his chest, I'm asking for that cash surety bond with a tether to maintain, and of course, no contact with Mr. Pitts.
Ms. Harris?
Your Honor, we have no objection to no contact. Complaining witness, Mr. Pitts. Ms. Winder has no contacts,
no prior criminal history, and to put it in her words, she's had never been handcuffed before. She's employed at a movie theater. She has 2 years of college. She understands the importance of returning for every court date. She will not have any contact with the complaining witness, Mr. Pitts, and she will not go to to where Mr. Pitts lives. The allegation of where the offense took place is Ms. Winder's home. So we're asking for a personal bond for that reason, and she has no history of not appearing for court. And we're stating that with respect to bond and keeping the court's objective of keeping Mr. Pitts safe, Ms. Winder won't have any contact with him and will not go to where he lives or where he works. Thank you.
$10,000 personal bond, Ms. Winder. You're not possessing any handguns, firearms, other dangerous weapons. No contact with J. Pitts. GPS tether. 9 p.m. to 6 a.m. curfew. Pre-trial, strike that. Probable cause July 3rd, criminal examination July 9th. Both in front of Judge Jack K. Ms. Winder, do you have any questions regarding your bond and or court dates?
What's my bond? I don't know what's going on.
$10,000 personal bond. You don't have to have any contact with Mr. Pitts. You got to possess any handguns, firearms, other dangerous weapons. Before you leave, you'll be fitted with a GPS tether. You'll have a 9 p.m. to 6 a.m. curfew.
Ms. Winder, you don't have to pay any money to get out.
What are your work hours, ma'am?
Huh?
What are your work hours?
To 1 a.m. I'm a closer. I'm a team lead. I'm a closer. I work 5 to 12 every shift. If it's not 5 to 12, it's 12 to 8 p.m.
All right. I have your GPS tether, no restrictions.
Thank you.
Have a seat in the chair. Say your full name. Jasmine C. Brown.
All right. Are you related to the football player from Michigan?
No, I'm not. I wish I was.
All right. Ms. Sebron, you have some traffic matters in which you failed to appear in court for. As a result of your failure to appear, warrants for your arrest were issued. The court's going to set aside these arrest warrants, give you a personal bond in each of these misdemeanor matters that carries a maximum penalty of up to 90 days in jail and or a $500 fine. You have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney. You can afford an attorney, one will be appointed on behalf. Tickets are P1001176. Driving a registered motor vehicle, no insurance misdemeanor, failed display of valid operator's license. Ticket P1246962. Driving license suspended, driving a registered motor vehicle, no insurance misdemeanor. Ticket P1343448. Improper plates, driver's license not required. Ticket P1343462. No insurance misdemeanor. Driving a registered motor vehicle. Ticket 124671781. Driver license not valid, and ticket 398429. No operator's license person, no insurance misdemeanor. In each of these misdemeanor matters, ma'am, you're going to personal bond or dollar amount. Pre-trial July 10th in front of Judge Roberta Archer at 9 a.m. Now to your main matter. It's case number 250-583-4201. Piece of the Michigan, Ms. Jasmine Sebron. Appearances, please.
Lisa Coyle appearing on behalf of the people.
Christina Harris on behalf of Jasmine Seaborn, who stands mute, waives the formal reading of the complaint, and Ms. Seaborn has been advised of and understands her statutory and constitutional rights.
All right, the court will enter not guilty plea on behalf of Ms. Sebron. Bond request, Mrs. Coyle.
Your Honor, I do note that I'm not aware of any criminal history for Ms. Sebron. The complainant in this matter is a 14-year-old female. The defendant is the complainant's boyfriend's mother, in which the allegations are that the defendant struck her in the face and cut her on the face with a box cutter. Officers did observe an inch-long cut to the complainant's face with dried blood. The defendant herself admitted she was intoxicated, and that, like I said, the complainant had 2 cuts to her face, one to her forehead and one to her cheek, both on the same side.
And what's concerning me is there's absolutely zero expression on her face as Miss Coyle is reading the charges. It's almost as if she's not ashamed at all, or like she's proud that she cut a 14-year-old face with a box cutter.
Your Honor, for that reason, the people are asking for a $10,000 cash surety with an alcohol tether and no contact, of course. People believe that alcohol may have played a substantial role, but this is a 14-year-old minor in which these are cuts to her face. And it's unfortunate, which I see many times women use box cutters in these cases, and they go after a woman's face. And they don't go after their body, they go after her face, because that's a way of marring her attractiveness. So it is sad. This young woman is 14. So that's why I'm asking for that $10,000 cash surety bond and an alcohol tether. Thank you.
In response, Your Honor?
Ms. Harris?
In response, Your Honor, Ms. Seaborn has absolutely no criminal history, no probation, no parole. She's employed at a retail establishment. She understands the severity of these allegations, and she will return for all future court hearing dates. She won't have any contact with the alleged complaining witness herein, but this case will be proved to be an issue of self-defense, Your Honor. Ms. Seaborn stated that the complaining witness harassed her and ran up to her and attacked her, and she defended herself, Your Honor. Ms. Seaborn will return for all future court hearing dates. She will not have any contact with the complaining witness, or the Blackstone Street address is where Ms. Seaborn's house. It is not where the complaining witness lives. So we're asking
what is the relationship between the complaining witness and Ms. Seaborn?
Ms. Seaborn is the boyfriend, complaining witness's boyfriend's mother. So she's not related to her at all. It's her boyfriend's mother, the complainant.
Okay.
Ms. Seaborn, the complaining witness, 14, has a boyfriend, and this is, thank you.
Wow. 14, times have changed. 14-year-old female with a boyfriend. I remember the age was 16 and up.
The boy is 19.
Oh, that makes it even worse.
Thank you, Ms. Seaborn.
Oh, so your 19-year-old son is in a relationship with a 14-year-old girl that you felt so threatened by that you took a box cutter to her face. Gotcha.
Yeah, that's not good for the son.
Yeah. Okay. All right. Court having heard argument as to bond. And there are allegations that Ms. Seaborn was intoxicated and she had a box cutter. And I assume the box cutter, no response to this, is due to her work that you frequently have. All right, Ms. Seaborn.
I only had my box cutter because she had.
Miss Seaborn, please don't say anything.
Ma'am, listen to your attorney. You may say something that you probably didn't want to say that may affect the bond I give you. Okay? So it's in your best interest to remain silent. Is that clear, ma'am? Okay. All right, the court having heard argument as the bond in this matter. What are Ms. C. Brown's work hours?
Ms. C. Brown, what hours do you work?
I have flexible. Sometimes I work in the morning, sometimes I work in the afternoon. Like last week I worked from 8 in the morning till 4 in the afternoon, and sometimes I sleep like 4 to 9 p.m. at night.
Okay.
Your Honor, did
And
you
it's
hear
considered-
that? 8 to 4 or either 4 to 9?
Let me just suffice it to say, is it fair to say, ma'am, you have a varied work schedule? It's not consistent?
No, it's consistent, it's just flexible because my shift is open. So 1 week I might work a morning shift, or next week I might work a night shift.
That's what I said. Your work hours are varied.
Oh, yes, they vary. I'm sorry, I didn't understand.
She works in a retail establishment, Your Honor.
I gathered that part, and at working at a retail establishment, it's not uncommon to have a box cutter because you got to cut boxes and put stuff on the shelves. I used to do that when I was a teenager, so I know. So that's part of the excuse as to why she had a box cutter in her hand, because you have to have it from back and forth to working, and sometimes you take them home inadvertently or whatever. So I understand the box cutter working in a retail establishment, because there's a ton of boxes you have to cut open and shelf for retail goods. In addition, this incident occurred at her home on Blackstone, an address. I'm going to, in light of that, I'm going to give Ms. C. Brown the benefit of the doubt and give her a personal bond in this matter. A $10,000 personal bond. No handgun, firearms, other dangerous weapons, no box cutters, no contact with Ms. Scales. Does your son live with you, ma'am?
My son live with me?
Yes.
Yes, most of my kids live with me. I have 3 of them. I have a 17-year-old, 11-year-old, and a 9-year-old.
All right, you're not to have any contact with the complaining witness in this matter, the 14-year-old. It seems like one of your children invited her to your house.
No, my 17-year-old.
Okay, ma'am.
Ms. Seaborn, please be silent and listen to the court. Thank you.
Oh, he's asking a question.
Okay, no, I was not asking you anything. I'm telling you, you're not to possess any handguns, firearms, other dangerous weapons. No contact with the complaining witness in this matter. It appears, and I'm speculating, that one of your children more than likely invited her to the house. I would emphasize to your children, so long as they live with you, that she is not invited over to the house. Is that clear, ma'am? Is that clear, ma'am?
Yes, that's clear.
Okay. Probable cause would be July 3rd, preliminary examination July 10th. In addition, no alcohol. All right, Ms. Sebron, do you have any questions regarding the bond and or court dates?
No, I do not.
All right, step aside, please.
All right, court will recall the matter of State of Michigan versus Billie Jean McMurphy. It's file 24-43173-SM, set for a probation violation today. Ms. McMurphy, why are you so late appearing in court?
I don't know how to do all this Zoom stuff. I can't figure it out to save my life.
Well, you're here now.
Yes, I had to call the court to figure it out.
What stopped you from doing that yesterday?
I mean, yesterday.
You could have called the court and asked how to do it yesterday so that you were prepared for today.
Oh my God. You there?
I'm here. I didn't hear you
Okay,
respond to my
it keeps
question.
freezing. I'm sorry. What do you mean yesterday?
Why didn't you,
I,
if you knew you didn't know how to do it, why didn't you call somebody yesterday so that you were prepared for today?
I have been trying to do it.
Who did you ask?
I had my son coming hook it up for me. And then
So
it
why
wouldn't
were you
let
late?
me. I've been having problems with my internet and stuff since the storm. So I don't barely have internet at my house anymore.
So where are you at right now?
I'm at my house. He has to connect to the stupid Wi-Fi booster pack and all kinds of stupid stuff.
All right.
But I have tried to comply with the probation. I mean, I gave her a letter. I have sent email after email and never get no response.
Well, here's the problem. If you're not going to appear on time, you run the risk of me issuing a bench warrant or taking other action. So but I'll waive that today because you did show up. Okay. However, there is a probation violation allegation against you that reads as follows: that you failed to report to probation in June, you failed to complete your mental health assessment, failed to provide
I
proof of
have.
counseling. Ma'am, let me read it. Let me finish.
I am, Your Honor. I'm sorry.
You failed to provide proof of counseling. You failed to complete your work camp, including a sanctioned work camp day from the first technical probation violation. And the recommendation is that we extend your probation for 6 months with no fee, but that you also serve 5 days in jail. If you, do you understand the allegations against you?
Yes, Your Honor, but I did complete the work camp at the dump where they told me I could.
When did you do that?
I did it in February and March.
Did you provide
And
proof
I
of
had a
that
letter
to
from
Ms.
my
Hill?
doctor.
I'm sorry, I didn't hear you.
I said, and I have a letter from a doctor saying that I have completed and I have been nonstop complying.
Have you given all that information to Ms. Hill?
I think I finally got it sent to her this morning. I've been trying to figure out how to get it to attach. I didn't know you had to hit the paperclip thing. And I did call her and explain this to her, but she's very short on the phone. She hangs up on me all the time.
Did you report for probation in June?
I called her, yes.
That's not what I asked. Did you report for probation?
As far as, I mean, I thought I did. I called her. That's all I've been doing. She hasn't told me what else to do.
Did you talk with her in June this
Yes,
month?
Your Honor. I have emails sent to her from June.
Okay. Ms. Hill, have you received recently some additional information from Ms. McMurphy?
So the last email I have from her is completely blank.
When was that?
That one was this morning. And it says paperwork in the subject, but there's nothing in it.
So how do I get it to attach? I can't get it to attach. That's not, I mean, can I show you what there? I have it. I don't know how to do this. I mean, I have the proof.
Ms. McMurphy, where do you live?
Atlanta, Michigan.
Okay. If you're not technologically savvy, if you don't know how to do those things and you don't have somebody to assist you, you may have to get in your car and come to the court and talk with the probation department.
Okay, I just recently got a car, so I can do that.
All right. Do you have your mental health assessment from your doctor?
Yeah, I mean, I have the note from my doctor saying that they have evaluated me, diagnosed me, and that I've been under their care for my disorders and everything, and that I've been complying with all the stuff and taking my medicine as prescribed.
All right. And do you have proof that you went and did the work camp day that I told you to back in January?
Yes, you told me to have it done by February 14th, as I recall.
All All right, so
And
what
I
I'm
did it
gonna
on
do is
February 3rd.
all right, so what I'm gonna do is I'm gonna give you a chance to bring that paperwork in to Ms. Hill so that she can see it and that she can make an assessment of it, because all she has right now is a big fat nothing. And it may be that you simply aren't technologically able to get that to her through the email. So I'm going to give you a chance to get it to her in person. Ms. Hill, when would you like her to show up?
I will be here tomorrow all day from 8 to 4:30.
8 to 4:30 tomorrow.
Ms. McMurphy, are you able to do that?
Yes, I'll make it happen.
All right. If you guys can reach an agreement as to what needs to happen after this, then I won't need to talk to you anymore. However, if Ms. Hill is not satisfied, or if there's some other issue that comes up, we'll simply re-adjourn or adjourn this matter and we'll reschedule it in the future. All right?
So, is there added time or what? I mean, it just gets
There isn't anything. I want to give you a chance to meet with Ms. Hill first before I decide what to do. If she's satisfied, if you've done everything that you're supposed to do and the paperwork looks right, then there may not be a need for you to have to do anything additional. However, if she's not satisfied and she wants to go forward with something, you'll have the right to come back to court and to tell me about what that issue is and to say your side of the story on it. So you're not losing anything. I'm just giving you a chance to give the paperwork to Ms. Hill and for you to better understand how she wants you to report and when you need to report and what you need to say to her when you do report. All right. So we'll adjourn. You're going to meet with her tomorrow?
Yes, between 8 and 4.
And then we'll go from there. All right.
Okay,
Thank you very much
so
for being
much
here today.
Yep, thank you.
That's all. State of Michigan versus Dylan Curtis, file 25-43715-SM.
Here he comes.
All right, I do see Mr. Curtis is with us. Mr. Truce is here as well as his counsel. Looks like this is set for a status conference. Do we have a resolution of this matter?
Yes, Your Honor, I believe we do. Richard Truce appearing on behalf of Mr. Curtis. Your Honor, we do have a resolution. It's part of a global resolution that resolves the case here as well as is going to resolve a case in Crawford County. I informed the court of that because it's going to inform how I ask the court to proceed after we do the plea today. So it contemplates that in this county, he would be admitting to count 2. That's the malicious destruction of, I believe, a building.
Yes.
It was a window.
For a dismissal of count 1. Although it may not matter in terms of the plea here, it also contemplates that he would be pleading to a domestic violence in Crawford County for dismissal of count 2 there.
Mr. Fortier, is that an accurate statement of the agreement?
It appears to be. Yes, malicious destruction of a building with restitution.
I don't mean to interrupt, Your Honor, but I would like to point out that the window has already been fixed. It was fixed, I think, not even 2 days after I had paid my mom to get it fixed because I'm not allowed on the property of any sorts. I had paid my mom to get it fixed and she had paid for it to get it fixed. And as I'm concerned, they had fixed it and it has been fixed.
All right, good. I appreciate that. Thank you very much. All right, Mr. Curtis, you've heard what the lawyers have said. Is that what you want to do?
Yes, Your Honor.
All right. I need you to listen carefully because if you do that, you'd be giving up certain rights. And I want you to make sure that you understand those rights ahead of time so you can determine what to do with them. If you enter this plea, you'd be giving up your trial rights. And those trial rights include the right to have a trial by a judge or by a jury. You would continue to have the right to be represented by an attorney. Mr. Truce would continue to represent you whether or not you had a trial or not. However, you'd also be giving up the right to see, hear, and question the witnesses at trial. You'd be giving up the right to present witnesses in your own defense and to get an order from the court called a subpoena to require those witnesses to appear and testify. You'd also be giving up your right to testify or to remain silent at trial and to not have that silence used against you. You'd also be giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt and to have the burden of proof remain with the prosecutor. And finally, you'd be giving up your right to appeal automatically from a jury trial or a bench trial. And you might be limited on a plea to asking the court for permission to appeal. You understand all of those rights?
Yes, Your Honor.
You have any questions about any of those rights?
No, I would also like to point out that because I didn't mean to break the window, I was trying to bang on the window to get in.
We'll get to that in just a minute. We'll get there. Just I know this is hard for you to slow down a little bit, but I just need you to slow down. Let me take it a little bit at a time. So, knowing all of those things that I just explained to you, do you still wish to enter your plea today?
Yes, Your Honor.
All right. In order to do that, I have to take some testimony from you. So I want you to raise your right hand. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right. Put your hand down. Other than this plea agreement, has anybody promised you anything to get you to plead today?
No, Your Honor.
Has anybody threatened you in any way to get you to plead today?
No, Your Honor.
Are you doing this of your own free choice and free will?
Yes, Your Honor.
All right. The charge that you're going to plead to, count 2 of the complaint that was made against you says that on or about May the 8th of 2025 in Otsego Lake Township of Otsego County, that you did willfully and maliciously destroy or injure a building. It uses the words or its appurtenances, things that go along with the building, like a window. Located at 156 Primrose Trail that belonged to Francis Curtis, and the amount of damage or injury was less than $200. Is that what you did?
Yes, Your Honor, but I would like to state out that the house that is owned by is not owned by my father. It is owned by my sister.
All right. Was the building that was injured or damaged, was that at 156 Primrose Trail?
Yes, Your Honor.
Yeah, but it wasn't owned by you. I think that's kind of the whole point.
And what did you do to do damage to that building?
I was trying to bang on the window to get inside to get my stuff because my pregnant fiance, my pregnant girlfriend at the time, was in the house, and he had locked her in the house, and he wouldn't let her get out or wouldn't let us get in to get my stuff because we had an argument, and he was kicking me out, and I wanted to go in and get in my stuff, so I tried to bang on the already cracked window. It was already damaged as it was, and
Okay. Mr. Curtis, what you're telling me is that you didn't do anything wrong. If you're going to plead, and you're certainly I'm certainly. Hang on, let me explain it to you. If you want to say I didn't do anything wrong, that's your right. You have the right to do that. However, if you're going to enter a plea and take advantage of a plea agreement, you have to tell me that you did something wrong. So
yes, Your Honor,
the question is, did you do something wrong? And
yes,
what was it?
I did completely break the window.
All right. Accidentally is not doing something wrong. You may be responsible for the payment for the window, but it's not a crime to accidentally break a window.
Okay.
You have to do it and the words in the statute say willfully and maliciously. And that means that you did it on purpose and you did it without excuse. Okay. So what you're telling me is that you have an excuse and it wasn't on purpose. It was an accident. If you want to say that, that's fine, but you're going to have a trial because the prosecutor is saying that that's not true, that you did it willfully and maliciously. So do you need some time to speak with your attorney about this?
No, Your Honor.
All right. So did you willfully and maliciously, that is not accidentally and on purpose, break the window?
Yes, Your Honor.
All right. And you're sure about that?
Yes, Your Honor.
Because you won't be able to change your mind later. And once I accept the plea, that's the end of that discussion. Do you understand that?
Yes, Your Honor.
So let me ask you one final time. Did you willfully and maliciously, that is intentionally and on purpose and without excuse, break the window?
Yes, Your Honor.
All right. And you've told me already that the window's already been fixed, right?
Yes, Your Honor. It was, I believe, got fixed at least 2 or 3 days after the incident had happened. I believe, I don't remember when I had got arrested for the incident, but I believe, because I was in jail at the time, but I had money on me, so I had my
All right.
girlfriend
All right,
give it
Mr.
to my
Curtis, Mr. Curtis, slow down. The answer to that question is yes, sir, right? Yes, the window has been fixed. That's all I need right now. Thank you very much. All right. Are either attorney, do either attorney have any questions as to the factual basis?
No, Your Honor.
No, Your Honor.
Are either of the attorneys aware of any promises, threats, or inducements not stated on the record?
No, Your Honor.
No, Your Honor.
Do both attorneys believe that I've complied with the court rule as to plea taking?
Yes, Your Honor.
Yes, Your Honor.
All right, let me catch up with my paperwork here. All right, Mr. Truce, you mentioned something about maybe needing an adjournment of some kind because of the Crawford County case. Do you wish to proceed to sentencing today, or do you want to wait on that?
Well, so I think necessarily the prosecutor is going to ask for an adjournment because I think his victim has a right to be present or to speak at a sentencing. So I think that has to happen. My suggestion to the court is going to be on July 29th. We're in front of Judge Burmeister, where we expect to effectuate sort of the second half of this agreement. I would suggest that we schedule the sentencing to follow that. It's my intentions, and I discussed with Ms. Brucker. I'm likely going to ask the court not to supervise him here because of what we anticipate in Crawford County. And I think it just becomes easier for everyone there if we've already effectuated that.
So the plea in Crawford County is when?
We anticipate that will be July 29th. That's his next court date there.
So we could come back here on July 31st, which
I
would be
think
the
that'd be
Thursday
just
following. We have room then?
Yep.
All right, so we will send out notice. It'll likely be the morning docket, but I don't guarantee that because I don't set those times. But July the 31st, we'll adjourn sentencing. Mr. Fortier, is that okay with you?
Yes, Judge.
And then we can have the victim impact statement at that time. So 7/31/25 for sentencing. I'll see everybody then. Thank you very much. That's all for today.
All right, DDC, can I ask a favor of you? DDC, can I ask a favor?
I am so sorry I was muted. Yeah, I do that from time to time. Yeah, sorry. Okay, this case involves a child. So, I'm gonna just let you guys know if you have to duck out now, I won't be offended. But, it is emotional, it is hard to listen to, and it does involve a child that did not make it. So for those of you who cannot hear that, I love you and I understand, and I hope you have a fantastic night. For those of you who are going to stick with us through this, we're all in this together.
Is anybody there for me to ask a favor of? Yes, Your Honor. Can we do Sherman Jones and the two Joneses? Can you bring one on the female side and one on the male side? Can we do those two together? Hey, for Your Honor. I'm sorry? Sherman Jones. Hey, go get Sherman Jones. And some Sambagita Jones as well for the female side. So you can do those both together. All right, what's your name, ma'am?
Sambagita Jones.
All right, what's your name, sir?
Herman Devon Jones.
Okay. Did either of you retain an attorney?
Yes, sir.
What's your attorney's name?
Vincent Hadash.
That was him. All right, where'd he go? Give me one moment. Your attorney was just in the courtroom. We gotta locate him.
Your Honor, I'll
Was he
take a look out in
representing
the
both of
hallway
you?
for him. I'll take a look out in the hallway for him.
Thank you. Was he representing both of you or just one of you?
Just Mrs.
Okay. All right. Give me one moment. Okay. I apologize. Ms. Jones, your attorney stepped in and we cannot find him.
Okay.
So can we pass on these two matters until we can locate him? All right, so Mr. and Ms. Jones, step aside, please. And
Sir.
DDC, mail side, we go straight down the list.
Copy, Your Honor.
Thank you. My apologies. He was just in here and I thought he just stepped outside, but we cannot find him. We need tethers for attorneys now. Okay. Mr. Hasha is on the record in Judge Jones' courtroom. I don't know how much longer he will be. Last I heard it was 5 minutes, maybe 10 minutes. Ms. Jones, how would you like to appear? How would you like to proceed, Ms. Jones? You want to wait for him?
Yes, sir.
Okay. All right, let's finish the females and then we'll have to wait for Mr. Hasha. So step aside, Ms. Jones. Let's finish the females and we can come back.
You want to do Mr. Jones?
No, I want to do them both together.
Okay.
All right, DDC, you can bring back the Joneses. Mr. Hasha has appeared.
Right, that's right.
Hasha, just let us know next time where you are.
I'm sorry, I was up with finishing an evidentiary hearing with Judge
No,
Jones.
but just let us know.
I apologize.
Okay. All right. I understand you got places to go, but we need to know where you are. All right. Ms. Jones. All right, can you bring out Sherman Jones, please? All right, give me one moment. All right. All right, both of you state your name for the record, please.
Ethan Jones.
Sherman Devon Jones.
This is case number 250-583-4101 and 250-583-4102. Appearances started with the Madam Prosecutor.
Thank you. Good afternoon now, Your Honor. Erin Wilmoth, P82085. I'm appearing on behalf of the people.
Good afternoon, Ms. Wilma. Thank you for your patience. For Mr. Jones.
Christina Harris, P52857, on behalf of Sherman Jones, who stands mute, waives the formal reading of the complaint, and Mr. Jones has been advised of and understands his statutory and constitutional rights.
All right, for Ms. Jones.
Your Honor,
It does.
Good afternoon, Vincent Haysha, P76506, Your Honor. With and on behalf of Santa Vita Jones, who is present via Zoom, I have no objection to proceeding in this manner for purposes of the arraignment. I would likewise indicate that while I have gone through an advice of rights with my client previously when I was retained, it's been approximately 9 months since I have gone through that. So I think procedurally, given the case, the court might need to advise Ms. Jones of her rights. I would, however, waive formal reading and stand review.
Waive a form of constitutional rights?
I waive formal reading of the.
Okay. Okay. All right.
I do just because I had not given her her constitutional rights in the last 9 months. Perhaps the court might want to do that given the nature of the case. I think that's appropriate.
All right, Ms. Harris and Mr. Hasha, on behalf of both your clients, the court will waive formal reading, stand mute, enter not guilty plea on behalf of both of your clients. Madam Prosecutor, proceed with your argument, please.
Thank you, Your Honor. I appreciate the court allowing me to be heard on bond. At this time, the more evidence will be presented at the preliminary exam, of course, but the allegations in this case are beyond egregious, Your Honor. This is the type of case that really leaves a pit in your stomach when you think of the unimaginable pain and suffering that was endured by young 9-year-old Owen. The evidence in this case supports that Owen suffered long-term severe physical abuse at the hands of both defendants who were his caregivers at the time. And there's quite a bit of a backstory there as to how the child came into their care, custody, and control, and at which point they no longer had legal authority and legal guardianship, but I will save that for the preliminary exam. Owen was first noticed with physical injuries as early as June of 2023 by a family member of the defendant, Sherman Jones, who contacted CPS and reported her concerns to CPS, and CPS failed to open an appropriate investigation as it relates to that. The medical evidence supports that Owen had scars, scratches, discoloration, and bruising over the entire surfaces of his body, Your Honor, head to toe. In fact, the medical report notes that there are too many scars to count on Owen's body. He was underweight with an extremely protruding stomach. He had healing fractures as well as acute fractures, which means non-healing close in time to his death. Fractures of the ribs, his pelvis, his elbow, scapula, humerus, his hands, his arms. I mean, the list goes on. And again, medical evidence will be provided at the preliminary exam. But what's more, Your Honor, is the evidence supports that Owen was concealed from the world, and the people's position is that was an effort to conceal the obvious signs of Owen's long-term abuse. He was often locked away in his bedroom, not allowed to go outside. He was not taken for normal wellness checks, physicals that children are often taken to. He was homeschooled. And again, it's our position that was in an effort to conceal what would be obvious to anybody else who was living outside of that house. The trauma suffered by Owen made him more susceptible to infection. And when Owen became sick with pneumonia, both defendants ignored his progressive symptoms and illness for weeks and never took him to receive medical care. And again, it's our position that that was also in an effort to conceal the injuries that we know are noted in the medical report and to continue concealing the ongoing severe abuse suffered by Owen. And ultimately, due to the significant long-term trauma Owen suffered at the hands of both defendants, Owen ultimately succumbed to the pneumonia, which would be extremely rare in a child who is healthy and who received appropriate medical care to succumb to pneumonia. And the medical examiner, as a result of the duration in which the medical examiner from his examination opined that this was a homicide due to the duration that these progressive symptoms were ignored. Owen's right lung was compressed because his entire right chest cavity was filled with pus. This child suffered, and he suffered for a long time. And what's interesting, Your Honor, if these two individuals are capable of concealing a child from not only others who might notice the abuse, but ultimately his own mother who was trying to get him back, what's to say they won't conceal themselves from these very, very serious charges? If there was ever a case for remand, Your Honor, this is it. And that's what the people are asking for. Thank you.
Okay. All right. Ms. Harris, first, please.
Thank you, Your Honor. In response, Mr. Jones is innocent unless proven guilty beyond a reasonable doubt. These are only allegations. As counsel stated, significant amounts of scientific evidence will come out in the future. If this was a situation where there were exigent circumstances and the necessity for investigation, Child Protective Services did not intervene and did not open an investigation despite a report being made. Additionally, the alleged incident date of this is June 1st of 2023. The warrant wasn't issued until more than 2 years later. I'm stating that these are allegations, that Mr. Jones is employed on a full-time basis, Monday through Friday, from 9 a.m. to 5:30 p.m. He is a holder of a bachelor's degree, and he understands the severity of these charges. We're asking for a personal bond in this matter for the reason that, yes, these are very serious charges. However, this matter dates back 2 years. Mr. Sherman Jones was going to work, living his life, and taking care of his business for a very long time before the state of Michigan sought these charges. He will comply with any conditions of the court. There's no necessity of an electronic tether because he has no criminal history, no pending cases, no contact with the criminal justice system. We're asking for a personal bond in this matter. Thank you, Your Honor, so that Mr. Jones can be released, return to work, and be out to assist with his defense. Thank you, Your Honor.
Okay, Mr. Hasha, before you proceed, Madam Prosecutor, what's the date of death for the complaining witness?
Thank you, Judge. I was going to ask to quickly interject so that the record was clear prior to the court moving on to the next defense counsel. The date of death is September 19th of 2024. The allegations are that the abuse began in as early as June of 2023 through the date of death of September 19th of 2024. As this court and even defense counsel realizes, these cases take a lot of investigation. There's a separate federal investigation that has been transpiring, as well as the investigation into the homicide. So we, as a prosecutor's office, like to do our due diligence before charging such serious allegations. But they're not.
One final question, Madam Prosecutor. What was the status, if any, of any CPS investigation?
So there were two CPS investigations regarding physical injuries that were observed by others that were merely closed without even looking into them. Now, I've been in this unit a long time, and I'm not going to get into the downfalls of CPS. I think that I can save that for another date, but I believe CPS failed this child as well. So there have been multiple complaints. They never opened an investigation until the child died.
And I hope that this case causes an investigation into CPS as well as into these two wood chipper Americans.
And then they opened an investigation. What's interesting too, Your Honor, is the information I have received is that both defendants are also licensed foster care workers. And that kind of piqued my interest as to why maybe CPS failed to open up an investigation. But again, CPS is not here. They are not charged with anything. But I don't think that changes the severe nature of the allegations, the concealment that occurred in this case.
All right, thank you. Mr. Hasha, proceed.
I'd like to just briefly respond to that, just briefly.
Hold on, Ms. Harris. Mr. Hasha first.
Thank you, Judge. Judge, these, I'll stress also the obvious notion that these are allegations and that there is a tremendous amount of scientific evidence that is yet to be discovered. And a tremendous amount of scientific evidence that's not been disclosed to the defense. But I'll indicate for the record is that my client is 41 years of age. She has no prior criminal history whatsoever. Ms. Womack was correct that my client is educated. She has a higher education through the University of Wisconsin, 2 years of experience there. And she was previously involved as the workforce development coordinator at New Foster Care. She's worked with children for virtually her entire adult life without so much as a suggestion that she was an abuser, that she committed acts of abuse. My records reflect that there were no actual investigations conducted by CPS as to Sam Pavito, or Sherman for that matter, but I won't speak to him, that she had never been so much as contacted by CPS, and that she had fostered 2 previous children before fostering Owen. So you take an adult lifetime of fostering children and working with children, and you have no indication whatsoever of abuse, save for, I think, the allegation that's been made by Ms. Moloff. See, that's what her investigation shows. That's her right to indicate that. But you had no indications by any entity that this was taking place with this particular individual, Miss Sam Pavito Jones. You have here, I think, at least is what I've heard, is there was a medical examination and there was a cause of death that included pneumonia, a clear medical condition. This was not blunt force trauma causing a collapse of some type of internal organ that caused the death. This was pneumonia. Now, I believe the people's theory is that the neglecting care led to this particular child, and God bless Owen, it led to him with appropriate treatment. I can gather that that's what their theory is. But we don't have that on the record at this point. We have
all of that will come out during testimony at a later date.
It can come out in testimony at a later date. That's
Right.
a consideration for bond, but we don't have that on this record. To suggest that there are no bond conditions that can be put in place for an individual who has no previous history, who has no history of abusing children, and who has been uniquely in a position to have been around children for her entire adult life, I think is inappropriate. I think that a cash bond in the area of 100,000, perhaps with a 10% provision, with a GPS tether, is a sufficient condition that can satisfy both the safety of the community and my client's return to court. My client has been aware of this particular investigation since she called 911 and then was ultimately taken over to headquarters to speak with law enforcement. She sat down with law enforcement when the tables turned and she felt like she might need to have an attorney present. She invoked, as is her right, retained counsel. But you know where she's been since? In the state of Michigan. If she wanted to flee or if she had any intention to do so, she would have left. She's been here. So to suggest that she is a flight risk or that there aren't conditions that can be set.
No, let me clarify for the record. I don't think either Mr. and Mrs. Jones are flight risk.
Thank you.
Okay.
To suggest that there aren't conditions that can satisfy the need to protect the community, I think is disingenuous. This is clearly a tragedy, Your Honor. I respect that, but this is a unique medical case, and there's going to be, I think, a difference in opinions once the matter proceeds to the examination of the trial phase of this. So I'd ask the court to take that into account. I think an appropriate bond is a cash bond in the circumstance. I'd ask that you consider the same.
One final question, Mr. Hasha, and then Ms. Harris, you can proceed briefly with your response. How long have they been running a foster care home? If you know.
At least dating back to 2018 and maybe even before that.
Okay, so at least so we're talking at least 5-7 years or so?
Correct.
Okay. All right, Ms. Harris, briefly.
I just wanted to state that with respect to Child Protective Services, maybe it's a situation of Child Protective Services did complete an investigation and closed it because there were no findings. So I'm saying that is something that could possibly be
Ms. Harris,
more.
Ms. Harris, are you speculating or do you have proof?
I'm stating that this counsel, opposing counsel, offered this information and she didn't have distinct information either as to what happened with those Child Protective Services investigations. So I'm stating
the investigation was never opened for
Hold on, Madam Prosecutor, hold on. Proceed, Ms. Harris, go ahead.
I'm asking, was it a situation of where Child Protective Services did complete the investigation and it was closed because of no.
Ms. Harris, she indicated they did not. So are you one of voir dire, Madam Prosecutor, or what?
No, Your Honor. I'm stating that this is a situation of where these are allegations, lots of evidence to be discovered, and lots of allegations without proof behind them. So Mr. Jones is innocent unless proven guilty beyond a reasonable doubt. And all these are allegations. Thank you.
Okay. All right. Thank you all, Madam Prosecutor, Ms. Harris, Mr. Hashem. All three of you will have given eloquent arguments in this matter. This is an unfortunate situation, and it's very, very rare before the court that I see such egregious and horrendous allegations. I've been practicing law for quite a while, but ever so often these cases kind of touch your emotions, and this is one of those cases. If the allegations are true, and I can see both parties are presumed innocent until proven guilty, at the very, very best or worst, or whatever you want to call it, this is extreme neglect that led to a child's death. Or the other way to look at it is that it was just egregious enough that this was neglect to the point of intentional homicide. The fact that the child was homeschooled, allegations of neglect to seeking medical treatment, and the fact that the medical examiner's report indicated the child died of pneumonia, all point toward extreme neglect or callous indifference toward the child's well-being. If the allegations are true that his physical condition was such to the point that is described by Madam Prosecutor, then it stands to reason, and I did not go to medical school, but I've had pneumonia before, that your immune system, even for an 8 or 9-year-old, even for that matter, even an adult, is very, very weakened. And that under normal circumstances, people do not succumb to pneumonia. But if the allegations are true that the abuse was such to that extent, then there's no doubt in my mind that the immune system would be weakened and would be vulnerable to a cold, pneumonia, or anything like that, that a person with normal immune systems and normal health would bounce back from. That's not unsurprising to the court. I find that these allegations are in fact true. This is egregious, and under MCR 6.106, the presumption of guilt has been met here under that court rule in this matter. And I'm going to remand both Mr. and Mrs. Jones in the custody of Wayne County Jail while this case is pending. This is very, very troubling. The court is very, very emotional on so many different sides in this matter. Probable cause, July 3rd, preliminary examination, July 10th, both in front of Judge Jack Kay. Is there anything else either counsel wants to put on the record? Starting with you, Madam Prosecutor.
I have nothing further at this time, Your Honor. Thank you.
Ms. Harris?
Nothing further, Your Honor.
Mr. Asha?
I asked my client be referred for a boundary determination hearing, but beyond that.
Mr. Asha, on remands, there are no boundary determination hearings.
We'll address that.
So then the next, and this goes for both you, Mr. and Mrs. Jones. The next time you'll have an opportunity to reevaluate the bond will be July 3rd in front of Judge Jack Kay at the probable cause hearing.
Very well. Thank you, Your
All
Honor.
right. Thank you both.
Thank you. I
Step
hope
aside,
everyone has a
please.
nice day.
All right, give me one moment, please.
Yeah, the judge had to go off camera for like 5 minutes or more, roughly. I mean, he couldn't take it either. I'm sorry to do that to you guys, but every once in a while, we're going to have that. Well, so I accidentally, I thought I put that at the end. Apparently I didn't. So there's some stuff after it, but I don't know what. I mean, I guess we can find out together. I have no idea. I have no idea what is after that. I know I plunked it in there. I thought I put it at the end, but there's something unedited after. Let's see. Oh, it's Judge Hillman. I don't know what is going to happen here.
All right, let's let everyone in, please. Okay, good afternoon, everyone. Welcome to the afternoon landlord-tenant docket. These are live court proceedings. Please conduct yourself as if you are in the courtroom. Please mute yourself if you have not already been muted until the court calls your case, so the court doesn't have background noise while conducting proceedings. Please do not be eating, drinking, smoking, wearing a hat, driving a vehicle, or moving around on the screen. Conduct yourself as if you are in court. All right, for all tenants, please listen carefully. You do have certain rights. You have the right to seek legal counsel. You cannot afford an attorney. The number for legal aid is in the materials provided to you by the court. The defendant has a right to have the case brought in a proper venue where you reside. The defendant has a right to demand a jury trial orally or in writing within 5 days after the initial hearing. Unless waived, the jury fee must be paid to the court within 5 days of the demand. In non-payment of rent cases, the Michigan Department of Health and Human Services or the local coordinated entry agency, housing assessment and resource agency, or the Federal Help for Homeless Veterans Program may be able to assist you with payment of some or all rent due. If you request a time extension under this section, you must file the form that is provided under the on the internet. Defendants do not need a judgment to receive assistance from the Michigan Department of Health and Human Services. The summons and complaint from this court case are sufficient. The Michigan and local community dispute resolution programs are available as possible sources of case resolution if agreed to by all parties. There is a possibility of a conditional dismissal pursuant to MCR 2.602 if approved by all parties. The conditional dismissal form is available online. The websites for both of those forms are in the materials that were provided to you by the court. First matter on the docket is Federal Home Loan Mortgage versus Joshua Nevels. Case number 252186LT. Is counsel here for the plaintiff?
Yes, good afternoon, Judge Solgul Plagany for plaintiff.
Okay, good afternoon. Is Joshua Nevels present? Joshua Nevels?
Yes, I am.
Okay, good afternoon.
Yes.
All right, Ms. Plagany, what's the nature of the plaintiff's complaint in this matter?
Judge, this is a summary process following a mortgage foreclosure where redemption has expired and no redemption was made. Redemption expired February 3rd of 2025. My client did have a relocation assistance agreement in place with Miss Amanda Nevels. That was not successful. She was to vacate by May 21st of this year.
Okay. All right. Is there anything you wanted to tell the court, Mr. Nevels, while you're here today?
Can I speak on behalf of this? I'm Amanda Nevels, his wife. I'm the one who takes care of this. I'm also on the documentation for the original mortgage to actually take care of it. He's not familiar with it. We did ask.
Hang on just a second. Ms. Plagany, is Ms. Nevels also a defendant in this matter?
She's considered an all other occupant, Judge. She is not the mortgagor. Only Mr. Nevels was the mortgagor.
Okay. All right. All right. So it's Miss Joy, is that right?
Amanda.
Okay. All right. You may, what would you like to tell the court?
The only thing that I'd like to speak on is we did ask for a payoff balance for, before the redemption period was over. We never received a thing. I called and I asked them what we needed to do in order to get that payoff balance. And they told me what I needed to do. We did the specifics. I have notes. I took notes. I copied everything I sent them. We never received a payoff balance, ever. I've never heard from them since. Nobody would return my calls after that initial one. I couldn't get through to any of their attorneys. So
maybe it's because your husband was the one who was supposed to be making those calls and not you.
we never even got the option to pay it off with a payoff balance. And that was before that February date.
Okay. Well, we're going to set this matter for a second hearing. We'll set it 2 weeks from today, and that will be in person for all parties. And if you have any documentation that you want to submit to the court as evidence, please bring it to court on that date. We're going to set it for July 10th at 2:30. And if you folks would like to speak with Ms. Plagany off the record, I'm willing to put you in a breakout room while you're both here today. Maybe
That would be amazing. I have a few questions.
Okay. All right, Ms. Plagany, is that okay with you?
That's fine, Judge.
Okay. All right. Then I'll send out new notices to the parties, and you folks are welcome to leave after you meet in the breakout room. We'll send out the invitation to breakout room right now.
Thank you, Judge.
Okay, thank you so much for your time. Thank you.
You're welcome. All right, next matter is Sycamore Village versus Angela Lamfier, case number 25-2194 LT. Is counsel here for the plaintiff?
Good afternoon, Your Honor. Danielle Polly for the plaintiff.
Okay, good afternoon. Is Angela Lamfier present?
Yes, Judge. Good afternoon.
Okay, good afternoon to you as well. All right, Ms. Polly, what's the nature of the plaintiff's complaint?
Your Honor, this is a non-payment of rent action for possession only. I have outstanding rent of $2,809.54, cost of $159.15, for a total of $2,968.69 as of today.
Okay. Ms. Lamfier, have you applied for assistance with the Michigan Department of Health and Human Services?
Yes, Your Honor. I'm working with a caseworker now.
Okay. And would you like to speak with, we have representatives, let's see, do we have representatives here today? Yes. We do. Okay. And we have representatives from DHS here. Today I could put you in a breakout room and you could have a conversation off the record, see how your application is going.
Okay, sounds perfect.
Okay. All right. I'm going to set this matter for a second hearing, July 10th at 2 p.m. That will be on the same Zoom station. Ms. Lamfier, are you able to use Zoom?
Yes.
Okay, because you're just on your phone right now and I can't see your picture, so I need to have you either in person or on Zoom next time, okay?
Okay.
Okay. All right. Anything else for the plaintiff?
Nothing further. Thank you.
Okay. All right. All right, Ms. Lamfier, I will put you with Mr. Patton from DHS in a breakout room and you can check on your application, okay?
Okay, sounds good, Your Honor. Thank you.
All right, you're welcome. That's all for today. Next matter is Blue Spruce Apartments versus Gloria Herrera and Damian James, case number 252198LT. Is counsel here for the plaintiff?
Good afternoon, Your Honor. Don Keski for the plaintiff. Possibly,
Okay.
possibly online is Debbie Wren from DTN, agent for the owner.
Okay, thank you. Is Gloria Herrera present?
Yes, I'm right here.
Okay, good afternoon. Are you able to turn your camera on?
I do not know how to.
Sometimes if you just scroll left or right, that will work. Is James Damian present?
Yes.
Okay, good afternoon.
Good afternoon.
All right, Mr. Keski, what's the nature of the plaintiff's complaint?
This is a possession, a complaint for possession for non-payment of rent, Your Honor.
Okay, and what's the amount of rent to retain possession through the end of June?
$2,283.98 plus court costs of $236.60 for a total of $2,520.58.
Okay. All right, Ms. Herrera and or Mr. Damian, have you applied for assistance through the Department of Health and Human Services?
No, I didn't know we could do that.
Okay, well, the materials that you received from the court has the information and the website for Department of Health and Human Services. So if you want to seek assistance, you need to do so right away because we're going to be coming back here for court 2 weeks from today. The second hearing will be July 10th at 2 p.m. and that will be on the same Zoom station. Is there anything else for the plaintiff today, Mr. Keski?
No, Your Honor, that would be it.
Okay. Anything else, Ms. Herrera or Mr. Damian?
No.
Okay. All right, then we'll see you back here on Zoom 2 weeks from today. If you want to get an application done, I suggest you do it right away. The instructions would be right in that material, those materials you received, that packet of materials from the court. It's Michigan Department of Health and Human Services, and you can go online and make the application.
Okay.
Okay, thank you. That's all for today.
All right.
Next matter is Aspen Houses versus Julia McCollum, case number 252204LT. Mr. Keski, you are here for the plaintiff?
Yes, Your Honor.
Okay, is Julia McCollum present? Can you unmute yourself, Ms. McCollum? They're just in the lower left-hand corner of your screen, look like a little microphone that has a red line through it. Ms. McCollum, can you unmute yourself? Looks like she's frozen. Yeah, let's. All right. Are you there, Ms. McCollum? Are you there, Ms. McCollum?
I am here as her daughter if there's a problem with her.
Okay, you're at a different location than she is?
Yes, I am.
Okay. Well, yeah, it looks like she's having difficulty using the technology, or maybe there's just not a good signal. I see her picture. Did we bring her back from the waiting room?
It's taken a long time to join.
It's taking a long time to rejoin, but we'll go ahead and get started, and you'll be willing as her daughter to convey the information to your mother.
Yes.
Ma'am? Okay.
Yes.
All right. Okay. All right. Mr. Keski, what's the nature of the plaintiff's complaint?
This is for possession for non-payment of rent, Your Honor.
And what is the rent to retain possession through the end of June?
The rent is $10,264.85. Court costs of $167.34 for a total of $10,432.19.
Okay. All right. That's a pretty large amount. All right. So Ms. Pastor Jacqueline, do you know whether your mother has applied for assistance through the Michigan Department of Health and Human Services?
No, she is not. She
Okay,
currently in Mississippi.
I see. All right. All right. Does she wish to contest this matter? Do you know? She doesn't live there anymore.
No, she doesn't live here anymore, but the numbers are inaccurate. So that's not correct.
Well, just so you understand, what the plaintiff is suing for is possession of the property.
Oh, sure.
And so that's the amount they claim would be owed to be paid up to date. But if the plan is not to stay in the property, then it really is irrelevant how much the money is if she doesn't wish to stay. So it may be beneficial to call Mr. Keski's office and see if you can work out some kind of an agreement. Perhaps the case could be dismissed if if possession of the property has been returned or is going to be lawfully returned.
Yes, it is.
Okay. All right. So I'm going to set this matter for a second hearing on July 10th at 2 p.m. and that will be on Zoom. If the parties have it worked out ahead of time, then you won't need to be here. But if it's not resolved, then we'll be back on Zoom. We will need your mother to be able to participate on Zoom. So if some kind of arrangement will need to be made if she wants to have a hearing on that date so that she can use Zoom. Okay.
Okay.
All right. Anything else for the plaintiff, Mr. Keski?
No, but she's welcome also to call Debbie Wren at DTN directly as well, which number is 517-371-5300.
Thank you.
Okay. Okay. All right. Anything else, Pastor Jacqueline?
No, thank you.
Okay.
Thank you.
All right. You're welcome. All right. That's all for the record. All right. Next matter is Hagedorn Investments LLC versus Chuck's Uwaji, case number 252206LT. Mr. Keski, you are here for the plaintiff?
Yes, Your Honor.
Is Chuck's Uwaji present? Chuck's Uwaji. Okay. This matter was set at 12:45. It's 1:01. Defendant has failed to appear. Appears that service was made by attachment only in this case. Was there a request for second mailing from the court, Mr. Keski?
No, there wasn't on this one.
Okay, then we'll set this for a second hearing on July 10th at 2 p.m. And this is a non-payment of rent possession only claim, is that right?
Yes, that's correct.
Okay. All right, that's all for the record in that matter. Thank you.
Thank you.
Next matter is the Lodges of East Lansing versus Alec Conan, case number 252208LT. Is counsel here for the plaintiff?
Good afternoon, Your Honor. Donald Osinski on behalf of plaintiff.
Good afternoon. Is Alec Conan present? Alec Conan. This matter was scheduled for a hearing at 12:45. It's now 1:02. Defendant has failed to appear. It appears that service was by posting only. Mr. Osinski, was there a second mailing requested by the plaintiff?
Yes, Your Honor.
Okay. All right. Do you have a request for the court?
Yes, with the non-appearance of the defendant, at this time, the plaintiff would like to request a default judgment in the matter. I am showing right to retain as $2,998.14. Court cost in the amount of $190.04 for a total redemptive amount of $3,188.18 to be paid, or the defendant to return possession of the property on or before July 7th or writ to issue.
Okay, very well. A default possession judgment is granted. as prayed for by the plaintiff, and you may submit the judgment for entry by the court, Mr. Osinski.
Thank you, Your Honor.
You're welcome. All right, next matter is the Lodges of East Lansing versus Patrick Fleming, case number 25-2210 LT. Is counsel here for, Mr. Osinski, you're here for the plaintiff?
That is correct, Your Honor. Good afternoon, Your Honor. Donald Osinski on behalf of the plaintiff.
Okay, good afternoon. Is Patrick Fleming present?
Yes, Your Honor, I'm here.
Okay, good afternoon, sir.
Good afternoon. How are you?
Fine, thank you. Are you able to turn on your camera, sir?
I attempted to. It said failed to connect the camera. I'm not sure why.
Okay, all right. Well, when we set it for a second hearing, I'm going to need you to be able to get your camera to work for that hearing, okay?
Absolutely.
All right. All right, Mr. Osinski, what's the nature of the plaintiff's complaint?
Yes, Your Honor. We are here on a non-payment of rent case, and I'm showing rent to retain as $8,582.89, court cost in the amount of $190.04, for a total redemptive amount of $8,772.93.
Okay, I missed the initial amount of money requested.
Yes, Your Honor. It was $8,582.89.
Okay, and this is a possession only claim?
That's correct, Your Honor.
Okay. All right, Mr. Fleming, have you applied for assistance with the Department of Health and Human Services?
I'm actually going to do that today. I wasn't aware that that was an option available to me. I did receive the documents fairly late, but I will start that today.
Right in the materials that you received from the court, it has the website you can go to make that application.
Okay.
So I'm going to set this for a second hearing on July 10th at 2 p.m. And we'll need to have your Zoom operational that day, sir.
Okay.
Okay, and we'll send new notices to the parties. Anything else for the plaintiff, Mr. Osinski?
No, Your Honor.
Okay, anything else, Mr. Fleming?
No, Your Honor.
Okay, that's all for today. Thank you.
All right. Thank you.
Have a great day, Your Honor.
You as well. Thank you. Next matter is the Ponds Cooperative versus Barbara Schultz, case number 25-2212 LT. Is counsel here for the plaintiff? Mr. Ray, are you there, sir?
Sorry, Your Honor, I'm in two courts.
Okay. Do you want me to pass and recall this matter?
I think they're going to wait on me on the other one, so.
Okay. All right. You want to state your appearance for the record?
Jeffrey Ray on behalf of Copper Bay, Your Honor. Or Ponds, I'm sorry. The Ponds.
Is Barbara Schultz present? Ms. Schultz, are you there? Thought I. Is she there previously? Okay. All right. This matter was set at 12:45. The defendant has failed to appear, and looks like service was made by posting in this matter. Was there a second mailing requested by the plaintiff, Mr. Ray?
Yes, Your Honor.
Okay. All right, then. Do you have a request for the court, Mr. Ray?
Yeah, we would move for entry of a possession judgment only. The rental arrearage is $9,652.23. Costs are $268.64. Total is $9,920.87.
Okay. A default judgment of possession is granted as prayed for by the plaintiff. An order of eviction may enter after July 7, 2025, unless the amount that was stated by the plaintiff is redeemed prior to that date. Anything else for the record, Mr. Ray?
Nothing further on that one, Your Honor.
Okay. All right. That's all for the record. Thank you. This matter is the Ponds Cooperative Homes, Inc. versus Teresa Taylor, case number 252214LT. Mr. Ray, you're here for the plaintiff?
Yes, Your Honor.
And ma'am, you are Teresa Taylor?
I am.
Okay, good afternoon.
Good afternoon.
All right, Mr. Ray, what's the nature of the plaintiff's complaint?
This is a non-payment of rent case, Your Honor. I'm showing a balance today of $533.83, cost of $248.64 for a total of $782.47.
They got one of them.
All right. Ms. Taylor, have you applied for assistance through the Department of Health and Human Services?
No, I didn't through them because I've been declined by them before, but I've gotten help from Meridian Township and from St. Vincent de Paul.
Okay. All right. So that's the rent through the end of June that's owing, Mr. Ray?
Correct.
Okay. All right. Well, we're going to set this matter for a second hearing on July 10th at 2 p.m. and it will be on this same Zoom station. Ms. Taylor, I expect if you can get assistance and pay that amount off prior to the July 1st date, that then the case would be dismissed. I expect July 1st. Is that when the new rent would be due, Mr. Ray?
Yes, Your Honor.
Okay. All right. Anything else for the plaintiff, Mr. Ray?
Nothing further. Thank you.
And is this a possession only claim, sir?
There's a money claim, but yeah.
Okay.
I don't
All
think
right.
there's personal service.
Money damages and possession. Okay.
Right. Yep.
All right. Ms. Taylor, anything else while we're here on the record?
Sure. Yeah, I'd just like some clarification. Mr. Ray, is this the same thing as the late fees that I owe, or is this something different?
This is everything that you owe.
Everything that I own, including the late fees, comes
Yes.
to 700 and some odd. Okay. Okay. And
Would you
so
like-
if I pay that off, then I let Mr. Ray know, and he lets you know, and then I don't have to come back, correct?
Yes. Yes. As long as it's all paid in full.
All right.
Do you have an email where Mr. Ray could email you the ledger so you can see exactly what they're claiming is owed?
I already have the ledger, and I do understand what's owed. Uh-huh.
Okay. All right, then that's all for today. We'll reschedule for July 10th. We'll send a new notice and if the matter's resolved, that'd be great. If not, we'll see you back here on the 10th.
Okay. Thank you. Thank you, Mr. Ray, for your help.
Thank you. Thank you, Your Honor.
Mhm.
Okay, you're welcome. Thank you both. Next matter is South Square Apartments versus Jedediah Naomi and Rebecca Butler, case number 252220LT. Is counsel here for the plaintiff?
Good afternoon, Your Honor. Don Keski for the plaintiff.
Okay, good afternoon. Is Jedediah Naomi present? Is Rebecca Butler present? All right. This matter was scheduled for a hearing at 12:45. It's now 1:12. Defendant has failed to appear. Does look like there was personal service on Jedediah Naomi only, not on Rebecca Butler. Was there a second mailing requested by the plaintiff, Mr. Keski?
No, there wasn't. There was not.
Okay. Well, rather than sever these two matters, we'll just set the matter for a second hearing on July the 10th at 2 p.m. And I'll make a note the defendants failed to appear. Is there anything else for the plaintiff?
Nothing else, Your Honor. Thank you.
Okay, thank you. This is a non-payment of rent possession only claim, is that right?
That's correct.
Okay, all right, very well. Okay, that's all for the record. Thank you. Next matter is South Square Apartments versus Eliuska Casas and Danielis Casas, case number 252222LT. Mr. Keski's here for the plaintiff. Is Aliuska Cassis present? Is Danielis Cascas present? All right, this matter was set for hearing at 12:45. It's now 1:14. Defendants have failed to appear. Was there a second mailing requested in this matter, Mr. Keski?
No, there wasn't.
It looks like like the previous case, one party was served personally, the other was served by substitution. So we'd be looking at setting this matter as well for the July 10th at 2 p.m.
Okay.
And that will be on Zoom. I'll make a note that the defendant failed to appear. This is a non-payment of rent possession only claim. Is that right, Mr. Keski?
That's correct.
Okay. All right. All right, then. That is all for the record.
All right. Thank you. Thank you.
Welcome. Next matter is Sheena Stiles versus Morgan Marlowe. Case number 25-2224 LT. Is counsel here for the plaintiff?
Good afternoon, Your Honor. Joy Whitty appearing in place of Pat Gallagher for Sheena Stiles.
Okay, good afternoon, Ms. Whitty. Is Morgan Marlowe present?
Yes, Your Honor, I'm here.
Okay, good afternoon. All right, Ms. Whitty, what's the nature of the plaintiff's complaint?
This is a possession-only case, termination of tenancy. We are not looking to collect any rent, and apparently the parties are well on their way to agreeing to a conditional dismissal with a vacate date of July 16.
Okay, all right, Ms. Marlowe, is that correct? You have some agreement that's been reached to have the case dismissed if you move out by a particular date?
Yes, Your Honor, that's correct. July 16th would be my last day.
Okay, and have you, Ms. Whitty, did you send a conditional dismissal form to Ms. Marlowe to review, or?
I don't know if she has received that yet. The rest of my cases aren't until 2 o'clock. I could be in a breakout room with her and firm up the details if you'd like. I see my client, Sheena Stiles, is also present. Is that a possibility?
Sure, yeah, that would save the court from needing to put it back on the court's docket. If the parties just want to acknowledge the agreement on the record, then that would resolve it today. So, Ms. Marlowe, you're willing to talk to Ms. Whitty off the record along with her client to just to go through the details of the conditional dismissal agreement?
Yes, Your Honor.
Okay, thank you then. We'll invite you to a breakout room, and if the parties come back on the record and put the conditional dismissal, then I'll just write that in the file and we won't have to set a new date.
Thank you, Your Honor.
Okay, thank you all. Next matter is Okemos Station versus Santos Vega. Case number 25-2244 LT. Ms. Palia, you are here for the plaintiff?
Yes.
Is Santos Vega present?
Yes, sir. Yes, Your Honor.
Okay, all right. Good afternoon.
Good afternoon, Your Honor.
All right, Ms. Palia, this is a non-payment of rent possession only case, is that right?
That's correct.
And what's the amount of rent to retain possession claimed by the plaintiff through the end of June?
I have rent of $3,802.54, court cost of $190 for a total of $3,992.54.
Mr. Vega, have you applied for assistance with the Michigan Department of Health and Human Services?
No, sir. No, there's really, no. We didn't have any
Okay.
intentions of keeping the unit either.
Okay, so it's your intention to move out?
Yeah, that's basically what we're trying to figure out is what do we do? Because basically the association has, and the property manager can verify this, I've been paying for everything in my home. and I was supposed to be being reimbursed for the stuff that I've been doing. And then I just got completely blacklisted from the property, and she came and apologized to me. And so I had to find another apartment when I got this letter. But I mean, you're talking, I've been in this home since, I think she pulled up my records. I've been in here since 2007, and I painted my whole unit, my cabinets. They made me do everything and said they were going to give me the money back, and then I got nothing.
Okay. Well, so this is a possession only claim. So
Yeah.
if you are no longer in possession, if you turn in the keys, turn over lawful possession to the plaintiff, then the case would be dismissed against you.
Yeah, that's what they told me. So she asked me when I was going to be out of here, and I told her I'll be out of here on the 4th or the 5th, and she said okay. But I still showed up here just because I didn't, I don't,
Okay.
I don't know what I'm supposed to do or what not supposed to do.
Okay. Well, I would assume that you prefer to not have a judgment against you. And so,
Yeah.
yeah. And so we're going to set this matter for a second hearing on July 10th at 2 p.m. It'll
Okay.
be on Zoom on the same station. We'll send out a new notice to the parties. And if you've moved out ahead of time and turned in the keys, then I expect the landlord would be dismissing the case against you.
Okay.
And otherwise, we'll come back on July 10th and I'll make a decision about the case, okay?
Sounds good. I appreciate it. Thank you so much.
You're welcome. Anything else, Miss Pollia, while you're here?
Just if Mr. Vega wants to confirm he's vacated by calling our office, our phone number's on the court paperwork ending in 9090.
Oh, to let you guys know when we're out?
Yeah, just so that I can make
Okay.
sure we process a dismissal timely for the court.
Yeah, I'd rather do that. Yeah, because I'm not getting anything here. So yeah, that's fine. All right.
Thank you,
So
Judge.
I'll get a hold of you. It'll probably be sooner, but I'll let you know for sure.
Thank you.
All right.
All
Thank
right.
you.
That's all for the record.
You guys have
All
a good day. Thank you, Your Honor.
Well, thank you. All right. Recalling the matter of Sheena Stiles versus Morgan Marlowe. Ms. Whitty, have you been able to discuss a resolution of this matter?
I have. The parties agreed that they do want to do a conditional dismissal with a move out date of July 16, 2025. I was given a current email address for the defendant, so I could send her a copy of that CD. She gave me her permission to sign it so we can get it filed today. She understands she has 3 business days to ask the court to set this aside if she does not want the court to enter it. And she understands that by settling it today, she's choosing not to have a trial. She's choosing not to retain an attorney.
Okay, thank you, Ms. Whitty. Ms. Marlowe, do you understand that the terms of the conditional dismissal?
Yes, Your Honor.
And are you in agreement with the terms?
Yes, Your Honor.
And you've given Ms. Whitty permission to sign the conditional dismissal form and file it with the court?
Yes, Your Honor.
Okay. All right, then. The court will make a note on the file. A conditional dismissal is to be filed. And the term is that you need to move out by the 16th. And if you fail to move out by that date, then the plaintiff would just need to file an affidavit with the court and a judgment would be entered against you and an immediate order evicting you would be entered. Do you understand that, Ms. Marlowe?
Yes, I understand, Your Honor.
Okay, and you're in agreement?
Yes, Your Honor.
Okay, all right. I think we've got it all for the record then. Thank you, ladies, for working this out together.
Thank you, Judge.
Thank you so much.
Thank you, everyone.
Thank you all.
Oh, that's the end of it.
Person listed as Lauren Lawler. What are you here for, ma'am?
She may have signed off. She's my realtor, sir.
Hey there.
Hi, I was just saw your name on the screen and we're done with our 12:45 docket, so I just wanted to make sure you're not waiting for another matter.
Beautiful. No, I'm trying to figure out how to get out of here. I apologize. Oh, I just figured it out. All right. Thank you, Your Honor.
Okay, you're welcome. I know.
Bye-bye.
All right, well, let's go ahead and mute and then we'll come.
Well, there you go. That was our palate cleanser. The absolute, complete, and total mystery docket that wasn't supposed to be there. And if I had edited it better, it wouldn't have been there. But, you know, Palmy and Mortimer Duke, you know, they had a field day with Morgan. Don't get into the bag. Don't get into the bag, Morgan. It's a trick. It's a trick. Oh, thank you guys so much for coming and hanging out with me through everything, especially through that last actual case, and then through the complete and total mystery docket. It is 2:27 in the morning here. I have no coffee, and my soda's empty, and I'm down to this much water. I gotta pee, but after that, and this, you know, what do you expect? So, you need your sleep. Dude, I'm just happy to see you. I love you. And I appreciate you being there for Russell. Thank you guys. You guys are the best. You really are. Oh my gosh. I love every one of you. Nitol? I think I can buy that at the drugstore. Isn't that a thing? Gosh, I hate picking this up when it's empty. It's so depressing. Possibly. He's kind of one of my favorites. All right, guys. Thank you again. And you all have a fantastic night. Be safe, be well, sleep sweet, and much love.